Regardless resident status abroad, living outside the shores of one's homeland can really be challenging and sometimes very difficult. Let's be sincere, to keep pace with updates from the host country abroad can really be difficult. Here on Dialogue in Diaspora, we give you every information, every news, every current issue you need to know on happenings outside the UK. Dialogue in Diaspora is your link between the world and the United Kingdom. It's your window to African development. Here, live on Ben Television. Hello, this is Voice coming to you from Ben Television. My name is Tunde Alabi. This is a program that is designed to bring to you information about legal matters here in the United Kingdom. All you need to know about legal issues, starting from immigration to anything that's got to do with legal matters in the UK. This is where we talk about it, and is our community law education program. Welcome to the program. My name is Tunde Alabi, and joining us here in the studio are community solicitor, that's the new title now she's getting, Jennifer Obaseki, senior partner at Obaseki Solicitors, here as usual on the program. So Jennifer, thank you for joining us on the program.
My pleasure.
Giving you a new title, community solicitor.
I love it. We've been supporting the community for more than 13 years, I'm pleased to say, so that's even very good. Many community awards, so I take the title.
How has it been speaking here, trying to reach out to members of the community, educating them about their rights, their responsibilities, about the role they should play, or what they shouldn't do, or what they should accept when it comes to legal matters in the United Kingdom?
It's very difficult because even though our community doesn't get the information firsthand or doesn't get the information and understand it, we are impacted so profoundly by immigration decisions. So from 2005, when we opened the office, we always tried to make it our point of the community, give them up-to-date information, have a free clinic on Fridays to make sure people can access just information, have the answers to questions. But we've seen so much change. We've seen now that they want to increase NHS surcharge to £1,000. That impacts so heavily on families in the community, and it's so important that we as a community support each other, number one, but stand up against things that do affect us adversely. When you have a decision as arbitrary as this, we all appreciate that the government has to exercise immigration control, of course, but when it impacts so profoundly in a negative manner against a certain sector of the community, we do need to outline the effect it's going to have on family relationships, our economy as a community, our ability to advance and develop, go to school, the fact that it might push certain people underground, the fact that it's going to impact so badly on the vulnerable. So it's been hard is the answer, but it is worthwhile because you also see the successes. You see the changes in the legislation when we push and we have justice for people who have not been treated well, justice against the Home Office, justice against people who have been treated badly by the police, success for families who have applied for contact or who are challenging government decisions to take children, or the ability to just build bridges and reveal situations where maybe somebody who's vulnerable has been abused for a long time and didn't feel empowered to step out of the situation. When you actually empower the community, it's I can say it's an immeasurable joy to me. That's why I'm still doing this job.
Immeasurable joy indeed. But let's look at the response of the community in terms of how the community takes the information being passed to them, bearing in mind that there are loads of scrupulous, very scrupulous individuals who parry themselves to be legal advisors, who take people's money and just use the same template they have for the same case over the years, and then eventually they give people wrong advice. What has been the reactions?
Well, thank goodness many of them are falling by the wayside. Many of them are being exposed. Many of them cannot survive because once, even if as customers, if you report the same solicitor over and over to the Home Office, the Home Office will realise that this person is not good.
Do our community actually report? Somebody who is under
Some
the
of
pressure of
these-
the Home Office
No.
now say you should go
Some
and
of
report
these,
to the solicitor.
some of these unscrupulous people, as you know that the community that they serve is vulnerable. They know that if you don't have documents, you're not going to complain because I took your 5,000, promised to get you an EA person, or took your 3,000, promised to get you someone to marry, or took your 2,000, promised that I'll make a family rights, human rights application for you, and didn't do nothing, or didn't do nothing that actually has a chance of being successful. No, many of them do realise that they might be able to get away with it. I've received reports of some solicitors who took thousands and thousands of pounds during the EEA piggy banking session, where they would get an EA person, pay them some thousands of pounds, and maybe put 3 or 4 people's applications on top of that EA's claim for residence as dependents, none of them knowing each other, all claiming to be family members, etc., etc. But some people were bold enough to report. Some lawyers that say, bring your money, I'm going to Nigeria, I won't send your application before I go. And despite taking the money and those people paying, those applications not going off. So we've all heard the horror stories, but there are still very good lawyers out there working very hard to make sure that our community get quality legal service. And it's not easy because obviously the forms are bigger, the grounds are slimmer. So making sure that you receive comprehensive advice from an experienced person, not somebody that's just going to fill out a form, not assess the merits that you have in achieving a successful result with that form, actually going to somebody that might say to you, look, the chance of you getting this is only 40%. Somebody that will tell you that. If somebody's going to tell you, look, you're going to be 80% chance successful, then yes, you know it's all right. If somebody says, look, it's 50-50, your grounds are not very strong, you don't really have the evidence, then you take that. But somebody that says, look, just give it to me, I'll get what you want. Be wary. Don't always want to hear what you want to hear. You want to hear qualified advice, substantiated advice. When somebody tells you that you qualify for something, let them also show you the law and the legal grounds that you meet to qualify that condition or that application. Those that say, leave me, I know what I'm doing, I've been doing this, I won't do my job. All these things that will put you off or make you feel a bit intimidated. No, as a professional, they should be glad to tell you how you qualify. They should be confident to tell you how you meet the criteria. Okay, so don't be, hard-eared to advice that you don't want to hear. You have to hear the good and the bad and make an informed decision for yourself and for your family.
One would imagine now, moving away from that, one would imagine what is happening in our community now, near and far, increase in detention, unlawful detention. First, tell us what will be considered as unlawful detention.
Right, the Home Office have to have grounds to detain you. As part of their controls on your release into the country, so if you've made an application and you've made it in time, the conditions on your leave to remain continue. But if you've come into the country as an overstayer or you've entered unlawfully, then you present to the Home Office by way of an application. So you make an application to regularise yourself. Maybe you've got a child, maybe you've entered a relationship. Then the Home Office can put conditions on the temporary admission that you have in the United Kingdom. Because first they've acknowledged that you're here usually by way of when you either get arrested or you get stopped by immigration and get asked to come and start reporting, or when you make an application and then you come to the attention of the authorities. So because you're in the country and you are in the public doing your day-to-day business, you have been granted temporary admission. So in other words, the Home Office know you're here and they're permitting you to be here and free while your application is being considered or until you make an application. Now, during that time, they normally issue you with an IS-96, a temporary admission document. And that document normally has your picture on it. And this is after you've usually had your fingerprint taken, confirmed your address. And then the Home Office may be satisfied that, okay, you're this person, this is your ID, and you're going to be signing, and this is the frequency in which you must come and report to the Home Office. Two things. Normally people start reporting but don't realise that if they haven't made an application, they need to. though you're going to report, your reporting is a way that the Home Office is monitoring your admission in the UK. So normally you're given time to make an application. Number two, they don't have to give you plenty of time. If they see that you've got no pending application, you have no intention to make one, you're here unlawfully, then they may detain you pending the time that they want to remove you administratively to your country of origin. Then secondly, if you've made an application and it's deemed that you may have had a history of absconding in the past, they may not want to allow you to have temporary admission again, so you may be detained as part and parcel of that the government's way of maintaining immigration control, and as well as their way of monitoring you as an unlawful entrant into the country. So some of the things the Home Office looks at before it makes that decision to detain you. One, your history. So if you've just popped up, they don't know you before, they may look at your age, your risk, if you've offended or anything like that. But if you've got an address that you are saying, this is where I am, you can monitor me from here, and the person living at the address gives you confirmation he's staying with me or she's staying with me while that application is pending or till they get the money to make that application, I'm supporting them, that stands in your favour. And again, if you don't have that history of non-compliance, so that is, you weren't asked to sign 5 years ago and then you just disappeared off the radar. And if you've also tried to maintain your lawfulness in the country, so maybe there's just been a short gap between applications, or you fell sick and that's why you weren't able to maintain your lawful status in the country. But the Home Office have to be satisfied that there's not a risk of, one, you absconding, and two, if the chances of you being removed are, let me say, not imminent. So one of the main things that the judges look at when they're granting bail, which is the next stage if you are detained, is looking at how close is the Home Office in decision making or ability to remove you. So if you have an address, if you have responsibilities such as childcare and you're caring for somebody, and you've complied with immigration rules in the past, then there's strong arguments that you should not be detained. One of the things you have to realise is there's over 5,000 people in the detention centres, and they're full to the brim. Most recently, there was a hunger strike in Yarlswood, I believe, and the women were not eating there. That's how bad the conditions were. And to my surprise, over 10 people died in detention last year. People commit suicide in detention. So the conditions are very, very bad. They're actually seen as, in some cases, not humane. We've had reports of thefts, reports of abuse in detention. In detention, whilst people are being detained under the care and control of the Home Office, indirectly through their contractors. So we've seen the deaths of people that have been removed while they're being removed as well. So detention should be the last thing that you would want to happen to you or to your relative. But we have situations as well where people are leaving a custodial sentence, and because of the fact that they are subject to immigration control, they're not being released into the community, but they get moved from Her Majesty's prisons into a detention facility. And there, again, once in the detention facility, the government is going to look at, is this person subject to automatic deportation? Have they had a sentence more than 12 months? Has the person got any pending applications? Do they have family ties? So if you are a serving prisoner and you've been given the notices by the Home Office in which you are given the questionnaires and the letter outlining that there's an intention to remove you at the end of your sentence, it's very important that you get help in filling out those forms. It's also very important that you realise that the right of appeal from abroad, even though it's been criticised, even though it's been told that it's unfair, you have to also outline those reasons why you would not be able to conduct an appeal for yourself from outside the United Kingdom. So you'd have to show that the imminent decision to remove you would be unfair, unreasonable, and would breach your human rights. So normally it involves your access to family care for children and the rights of other people, such as your children. But the difficulty we have is many people at this stage, because there's no legal aid, are usually representing themselves. Or if they can afford legal representation, we then have to look towards having solid surety for bail. Having surety is not compulsory, but it's ideal. Ideally, you're looking for 2 people or more that can stand for you and say that they are going to act as guardians on your admission, your temporary admission into the community while your case is being considered. Now, those 2 people usually offer financial security as well. But those are ideals. Many people still apply for bail with no sureties, with a bail hostel address from BID. Bail for Immigration Detainees is an organisation that helps people, often those who have been in detention for a while or those who cannot afford legal representation. But if you have 2 sureties or more, as I've said, and they are they're able to offer financial security, then you have a strong ground to fill out the form. You also have to write submissions, because when you send your bail application into the court, the Home Office then actually prepares a reply. That reply normally has your immigration history on it, whether it's good or bad, a series of summary of your applications, and also it should outline their intentions with you. So whether it's we intend to have this person interviewed by their embassy, or we're preparing travel documents, so that the judge has an idea as to how close they are to removing you. And if you have a pending application, you have family, you have an address, you have sureties, then you stand in strong stead to have a successful bail application. The problem is, in this country, you can only make a second bail application if the first one is refused after 28 days. So it's common and unfortunate that when we get to court, if a judge is not satisfied, for example, if a surety fails to bring their original ID to court, their original bank statements, even though you put your surety's names on the form and you expect that they are checked before coming to court, even while in court, they're subject to further scrutiny. Their passports are checked, their proof of address is checked, their bank statements, original ones, are often requested so that the total balance can be seen as to what it is on the day of application. Because when you make the application, you might have 10,000, and when you go to court, you might have overdraft. So they just check on these things. And again, if you've got offending behaviour, so if you've got a criminal record, your local probation service may be asked to confirm a report that they've checked you, your risk of offending, the history of your behaviour whilst in detention. So whether it's evident or not that you've been a reformed character, whether you've gone on courses to show that you have been rehabilitated, or also looked at. So these things are very important. We find that at the moment in detention we have EU nationals, we have nationals from outside the EU, again for differing reasons. But if the detention from the initial point is not justified and you are detained, you can have a good case for unlawful detention. Now this is very important. So if you're stopped by immigration, you show them that you have a pending application, you've been fully compliant, technically yes. If you are, you don't have a decision and you've never presented before, they can detain you until your application is determined. But would it be reasonable? It may be considered unreasonable. But if there's no grounds whatsoever to detain you, so for example, you had previously got leave to remain, you have a pending application, and suddenly you're just stopped by the police, and they want to just curtail your right to be free and move around, that's not justified. If you're stopped and you're an EU national and the Home Office don't believe that you're here exercising your treaty rights, they have no right just to detain you. And that's been happening quite a lot with black EU nationals. Either because the Home Office have been a bit sloppy on checking their documents, or they've not done it properly, not checked with the national embassy that this person's a French national or this person's a Spanish national.
Or dependent
yes.
of an EU national exercising a treaty right.
Correct. And they've just not checked properly, but detained that person for 1 week, 2 weeks, 3 weeks. Very unreasonable. And most recently there's been a case that's very important, and that's for somebody who spent a very long time in detention. And he was an Algerian national. And it became very...
Algerian,
yes. So it became very clear after him spending a long period of time, even though he had a very complex history, a long period of time in detention, that the Home Office had no ability to remove him to his original country. Why? Because Algeria can, if it's going to be unsafe to where you're moving somebody to, you can protest and you can challenge the decision to remove that person by way of judicial review. Again, if they're going to be facing criminal charges in that country and you can prove that person will not have a fair hearing, if the country the Home Office want to remove him to, does not accept them as a national of their country, it doesn't give the Home Office the right to keep you in detention indefinitely. Whilst in detention, there's a duty to maintain your welfare, there's a duty to carry out reviews, written reviews. It's so important that your human rights are maintained. So the standard of your food, your medical care must not be degraded simply because you're a foreign national. So in this particular case that I was referring to, the Home Office begrudgingly gave the gentleman bail, but when it became very clear that since they have no power or ability to remove him, they cannot continue to impose conditions on him. So those conditions had to be removed. The Home Office sought a challenge to this, but they unfortunately, well, I would say fortunately, lost. Because the court said you can't continue to impose conditions on somebody that you are not able to remove. You can't continue to detain them, then you can't continue to just impose bail conditions on them, restrictions on them. So any conditions that they wanted to do in regards to monitoring him had to be done through different legislation, not through the immigration legislation. But it's been interesting looking at the different cases that have come up. Cases like that, challenging detention, have been important. Cases, again, that are challenging the definitions of human rights. We've looked at family life as a main thing. And when it comes down to family life, we know that the family relations is important, children are important, and your activities in the local community. But most recently, there's been a very good decision that outlines that business activity can also be considered part of your private life.
When you're looking for a solicitor to deal with your case, you don't just look for any solicitor, you look for the right solicitor. An expert who knows what he's doing can deal with your case the right way, achieving the best results. Obaseki Solicitors has more than 100 years of specialist experience serving the local community in immigration law, property law, human rights legislation, civil and criminal litigation, family law, employment law, Sharia law, business law, maritime and commercial law, providing professional legal services globally in Africa, Asia and Europe. Be assured we'll be able to deal with your case the absolute right way with results. So, contact us today by phone on 020-7739-7549 or go online at www.legalpal.com.
Right, this is how far we can go on voice at this time. For now, we've been talking about illegal detention. We'll be talking about what impacts this program, and of course, our community solicitor, Jennifer Obaseki, the senior partner of Obaseki Solicitors. We have jointly made on our community awesome program in the last couple of years. We've touched a whole lot of lives. We've brought information to people, and Jennifer has actually done a great deal, winning local and international awards on helping vulnerable people, fighting the case involving members of the community to win issues, their legal battles, and so she's done very well. Congratulations on some of these local and that's actually been
thank the community,
international speakers. I see you travel around now speaking on a whole lot of issues. All right, well, one day I will climb up to the ladder as well. Don't worry, just be on the watcher. So far we can go on voice this day. My name is Tunde Alabi. Stay out of trouble. Enjoy the rest of the day.
Regardless, residents settled abroad, living outside the shores of one's homeland can really be challenging and sometimes very difficult. Let's be sincere, to keep pace with athletes from the host country abroad can really be difficult. Here on Dialogue in Diaspora, we give you every information, every news, every current issue you need to know on athletes outside the UK. Dialogue in Diaspora is your link between the world and the United Kingdom. It's your window with African development. Here, live on Ben Television.